Welcome to NYPTI's Decisions on the Go, using AI for over a decade to help you listen to New York State Court of Appeals decisions on the go. After the podcast, visit www.nypti.com/law to read the full decision.
People v. NH. Decided April 23, 2026. Rivera. The issue on appeal is whether, as a condition of a negotiated plea agreement, a defendant may waive a Penal Law 60.12 hearing to determine their eligibility for an alternative sentence under the Domestic Violence Survivors Justice Act, DVSJ. The legislature designed the DVSJ's alternative sentencing framework to remedy a systemic injustice of the criminal legal system. Specifically, the legislature recognized that the standard sentencing scheme fails to adequately consider how domestic violence impacts a survivor defendant's criminal conduct and their potential for rehabilitation, resulting in harsh and unfair sentences for many survivors. The DVSJ, in Penal Law 60.12, provides a survivor defendant with the opportunity to request a hearing to establish the impacts of domestic violence in their case and their eligibility for a lesser sentence that accords with the legislative purpose of fair and compassionate treatment of survivors. Here, defendant NH requested a reduced sentence under the DVSJ sentencing framework, or, in the alternative, a Section 60.12 hearing to demonstrate her eligibility for such a sentence. The prosecution subsequently offered, and NH accepted, a plea bargain contingent on NH's waiver of a Section 60.12 hearing. We hold that Section 60.12 hearings are not waivable as a condition of a plea agreement. Therefore, we reverse the appellate decision order and remit to Supreme Court for further proceedings. 1. The DVSA. Enacted in 2019, the DVSJA amended Penal Law Section 60.12 to establish an alternative sentencing framework for certain defendants who are survivors of domestic violence. We recently explained that the legislature enacted the DVSJA in recognition of the national epidemic of domestic violence and the failure of prior law to allow judges discretion to fully consider the impact of domestic violence in making sentencing determinations. People v. Brenda W.W. To that end, the DVSJA expands judicial discretion at the initial sentencing stage by permitting courts to sentence defendants to an alternative, less severe sentence. The reduced sentencing ranges available under the statute include determinate sentences and, in some cases, community-based alternative to incarceration program, Assembly Mem. at 6, see Penal Law Section 60.12. As amended, Penal Law Section 60.12 now provides that where a defendant has been convicted of an eligible offense and is pending sentencing, a judge may impose a sentence pursuant to the alternate DVSJA framework upon a determination following a hearing that 1. At the time of the instant offense, the defendant was a victim of domestic violence, subjected to substantial physical, sexual, or psychological abuse inflicted by a member of their family or household, as such term is defined in CPL 530.11. 2. Such abuse was a significant contributing factor to the defendant's criminal behavior. And 3. A sentence within the standard range provided by law would be unduly harsh considering the nature and circumstances of the crime and the history, character, and condition of the defendant. Penal Law Section 60.12(1). See also Assembly Mem. at 5. The statute also provides that the hearing court shall consider oral and written arguments, take testimony from witnesses offered by either party, and consider relevant evidence to assist in making its determination, and that reliable hearsay shall be admissible. Penal Law 60.12(1). Thus, the DVSJA requires a court to consider a defendant's history of domestic violence and its impact on their criminal behavior prior to imposing sentence, whether it ultimately opts to sentence the defendant under the standard penal law Article 70 sentencing scheme or the alternative DVSJ sentencing framework. This structure deliberately furthers the statutory purpose of permitting judges to adequately consider a survivor's history to impose an appropriate sentence. The DVSJA's legislative history reflects that prior to enactment, despite significant advances, New York had failed to reform the unjust ways in which the criminal justice system responds to and punishes domestic violence survivors who act to protect themselves from an abuser's violence. Assemblymem at 6. The narrow scope of the previous sentencing law for defendants who had experienced domestic violence, the Sentencing Reform Act of 1998, commonly referred to as Jenna's Law, constrained the sentencing judge's ability to fully consider how survivors' histories of domestic violence may have contributed to their commission of the offense. See Tamar Kraft Stolar et al. From Protection to Punishment, Post-Conviction Barriers to Justice for Domestic Violence Survivor Defendants in New York State at 1112, Avon Global Center for Women and Justice at Cornell Law School, and the Women in Prison Project of the Correctional Association. Scholarship at Cornell Law, a digital repository, June 1, 2011, available at https://scholarship.law.cornell.edu/Avon Clark/2/last accessed April 8, 2026. Assemblymem at 6. Asserting that the DVSJA would address shortcomings in the rarely used Jenna's Law, which state officials had thought would lead to less punitive sentencing for survivors, but unfortunately did not. The DVSJA created an alternative sentencing process intended to address these systemic defects by enabling sentencing judges to comprehensively consider, after a hearing, the effects of domestic abuse on a defendant's criminal conduct, and to take such effects into account when making sentencing determinations. See Assemblymem at 6, describing the problem the DVSJA intended to address as the harsh punishments imposed on domestic abuse survivors, much of which are a result of our state's current sentencing structure, which does not allow judges discretion to fully consider the impact of domestic violence when determining sentence lengths. The legislature sought to decrease the likelihood of survivors being victimized by the very system that should help protect them through long, unfair prison sentences. Thus, with the DVSJA's enactment, the legislature re-envisioned a fairer system of justice in which judges respond to qualifying survivors with compassion and assistance in the form of reduced prison sentences and non-incarceratory alternatives. 2. Factual and procedural history. The prosecution charged NH with, among other offenses, 1 count of attempted murder in the 2nd degree and 2 counts of assault in the 1st degree, arising from an incident at a party outside NH's home. After NH's abusive ex-boyfriend, RL, arrived at the party, an altercation broke out, during which NH's then-boyfriend was injured, and NH fled to her car to escape her former abuser. As she began driving away, she hit and ran over her sister's girlfriend. When she reversed, NH ran over the victim's body again and then drove forward, striking the victim 3 times before dragging her body down the street under the car. The victim survived but is permanently paralyzed. While the case was pending, NH's counsel submitted an application to the court requesting that it sentence NH under the DVSJA to 6 months incarceration followed by 5 years probation, or grant a hearing pursuant to Penal Law Section 60.12 to determine her eligibility for a reduced DVSJA sentence. Counsel supported the request with numerous scholarly articles on domestic violence and women in the criminal legal system, and the psychological effects of trauma and domestic violence. Counsel also submitted reports from a licensed psychologist and a forensic social worker, both conducted after NH's arrest and based on interviews with NH, her family members, and her service providers, as well as relevant documents. The psychologist also administered a diagnostic clinical assessment for post-traumatic stress disorder, PTSD, during NH's pretrial incarceration. The psychologist's report details NH's self-disclosed exposure to domestic violence, which began as a child when NH witnessed her mother's boyfriend repeatedly punch her. Then, as an adult, NH experienced repeated psychological and physical abuse by RL, the father of her child. According to NH, RL first physically assaulted her when she was 20 years old and 5 months pregnant, and his physical and verbal abuse escalated thereafter. After a period of separation due to the first incident of physical abuse, they resumed their relationship when their child was around 1 year old, and NH moved into RL's apartment. Their relationship quickly became volatile again, leading to repeated breakups and reconciliations. Each time, RL would become physically and verbally abusive. NH stated that as this pattern continued, she understood their relationship was toxic. She ended the relationship permanently when she was about 25 years old, approximately 2 or 3 years before the incident leading to her arrest. The psychologist's report also recounted NH's narrative of the events at the party, including that NH hit the victim with her car while trying to escape from RL, and what she perceived as a threat to her physical safety. According to the psychologist, NH described an extremely chaotic situation at the party before she ran to her car, including RL jumping on top of her and punching her, as he had in the past, and that she wanted desperately to get out from underneath him. Once NH got into her car, RL and NH's sister were banging on the windows, and NH stated that the car went from feeling like a super safe spot to feeling like I could die in there. The psychologist found NH's account to be credible, detailed, and highly consistent with her sister's report and other available sources, and noted that NH's description of the incident leading to the criminal charges suggests that her emotional reaction at that time may well have been impacted by her history of exposure to trauma and violence. The report concluded that NH's symptom presentation is consistent with a diagnosis of PTSD and noted that her scoring protocol reporting post-traumatic symptoms did not reflect an attempt to feign symptoms or malingering. The psychologist described NH as resilient and stated that she displays insight and the capacity for self-reflection, suggesting amenability for treatment. Further, NH appeared to be benefiting from various therapy and counseling services since the incident, had a stable educational and employment history, and had been able to support herself and her daughter in the past. The psychologist opined that earlier therapeutic services might have helped NH identify ways to interrupt the cycle of volatility between her and RL, but that she had gained considerable insight through therapy, both about the ways in which her life experiences have impacted her and about her emotional reactions. The psychologist recommended that NH continue trauma-focused psychotherapy. The forensic social worker conducted a biopsychosocial assessment and report to provide the court and district attorney's office with a better understanding of NH's traumatic history triggers that have directly contributed to her current circumstances. The report stated that NH's extensive history of abuse has played a major role in her daily living and has significantly impacted her behavioral response to perceived threats and violence. Noting NH's support network, her extensive domestic violence history, and her efforts to address her mental health challenges through clinical and therapeutic services, the report concluded that it would be unduly harsh for NH to be sentenced under the standard sentencing scheme because it would have a devastating impact on her life and her healing progress thus far, in addition to, and most significantly, for her daughter. The social worker recommended that NH be sentenced under the DVSJA. While NH's DVS-JA application was pending, and before any Penal Law Section 60.12 hearing, the prosecution offered, and NH accepted, a plea bargain in exchange for her waiver of the hearing and her right to appeal. Pursuant to the agreement, NH pleaded guilty to one count of first-degree reckless assault, Penal Law Section 120.10(3), in full satisfaction of the indictment, in exchange for a determinate sentence of 5 years imprisonment, followed by 5 years post-release supervision, PRS. During the plea proceeding, defense counsel argued that NH was entitled to the hearing and that asking her to waive it went against the spirit of why the law was created. The court, noting the absence of case law in this area, also expressed concern as to whether a defendant may waive a DVS-JA hearing as a condition of a negotiated plea agreement, but ultimately concluded that such a hearing was waivable. The court accepted NH's plea and imposed the promised sentence. The appellate division affirmed, concluding that Section 60.12 hearings are waivable as part of a plea agreement, and that the 5-year period of PRS imposed was not excessive in this case. A judge of this court granted NH leave to appeal. 3. A Penal Law Section 60.12 hearing is not waivable as a plea condition. NH's sole contention on appeal is that Penal Law Section 60.12 hearings are non-waivable and that she is therefore entitled to such a hearing to determine her eligibility for DVS-J relief. We agree. The statutory framework and purpose of the DVS-J Alternative Reduced Sentencing Framework reveal the legislature's intent to mitigate a systemic failure of the criminal legal system, which led to unduly harsh sentencing of domestic violence survivors. A. The primary consideration of courts in interpreting a statute is to ascertain and give effect to the intention of the legislature. People v. Galindo. As the clearest indicator of legislative intent is the statutory text, the starting point in any case of interpretation must always be the language itself, giving effect to the plain meaning thereof. Majeski v. Broadalbin, Perth Central School District. A statute must be construed as a whole, and its various sections must be considered together and with reference to each other. Matter of Payton v. New York City BOSD and Appeals. In appropriate circumstances, the court may inquire into the purpose of the legislation, which requires examination of the statutory context of the provision as well as its legislative history. We consider legislative history where the language of the statute is ambiguous or where a literal construction would lead to absurd or unreasonable consequences that are contrary to the purpose of the enactment. See Matter of Auerbach v. Board of Education of City School District of City of NY. B. While it is undisputed that a defendant may agree to forego many of their rights, even very important ones, during the course of plea negotiations, some rights are too valuable, both to the defendant and to the community, to be sacrificed in plea bargaining. See People v. Rudolph. Plea bargaining is a vital part of our criminal justice system, but the judicial acceptance of plea bargaining rests upon broader policy considerations. See People v. Seaberg. Thus, we have held that a defendant may only waive a guaranteed right when there is no constitutional or statutory mandate and no public policy prohibiting waiver. Conditions imposed as part of a plea arrangement are valid if the parties agree to them, and they do not violate any statute or contravene public policy. People v. Avery, citing Seaberg, see People v. Hansen, People v. Allen. The class of rights which may not be waived as part of a plea negotiation is grounded in the integrity of our criminal justice system and the reality of fairness in the process, and such rights implicate either an infirmity in the waiver itself or a public policy consideration that transcends the individual concerns of a particular defendant to obtain appellate review. See People v. Muniz, quoting Seaberg. In other words, for a right to be non-waivable, societal interests must be present that justify application of the narrow exception to the general rule that an accused may waive any right they enjoy as part of a plea bargain, quoting Allen. Those public policy considerations that transcend the individual concerns of a particular defendant may be grounded in the legislature's purpose in enacting a particular statute, see Muniz. As we discuss, such is the case here. Notably, many of the statutory and constitutional provisions enshrining rights that this court has deemed too valuable to be sacrificed in plea bargaining are silent on or do not expressly address the issue of waiverability. See e.g. People v. Armlin, no waiver of right to challenge competency to stand trial pursuant to CPL 730, People v. Blakely, no waiver of constitutionally protected right to a speedy trial, People v. Francabandera, no waiver of right to challenge legality of sentence or voluntariness of plea, cf. Rudolph, holding that a defendant cannot waive a youthful offender determination because CPL 720.21's requirement that, upon conviction of an eligible youth, the court must order a pre-sentence investigation of the defendant reflects a policy choice that there be a youthful offender determination in every case where the defendant is eligible, even where the defendant fails to request it or agrees to forego it as part of a plea bargain. C. Penal Law Section 60.12 provides that the court, upon a determination following a hearing, that a. At the time of the instant offense, the defendant was a victim of domestic violence subjected to substantial physical, sexual, or psychological abuse inflicted by a member of the same family or household, as such term is defined in CPL 530.11(1). B. Such abuse was a significant contributing factor to the defendant's criminal behavior. C. Having regard for the nature and circumstances of the crime and the history, character, and condition of the defendant, that a sentence of imprisonment pursuant to Penal Law Sections 70.00, 70.02, 70.06, or 70.71, 2 or 3, would be unduly harsh, may instead impose a sentence in accordance with this section. By its terms, Section 60.12 proceeds in 3 steps. First, it permits a defendant to request an eligibility hearing. Second, following the hearing, Section 60.12 requires the court to make findings of fact as to whether the defendant has met their evidentiary burden to establish their eligibility for an alternative sentence. If the defendant meets that burden, at the third step, the court may exercise its discretion to sentence the defendant as provided in Section 60.12, 2 through 11. For example, if the court had held a hearing on defendant's application in this case and determined that a DVSJA sentence was appropriate given her circumstances, it could have sentenced her to a vastly reduced sentence compared to what she would otherwise have been subject to under other provisions of the penal law. Here, NH's sentencing exposure on the top count in the indictment, attempted murder in the second degree, was a maximum prison sentence of 25 years and a minimum term of 5 years. By contrast, under the DVSJA, the court could have imposed a definite sentence of 1 year or less in prison, or probation, or a determinate sentence of between 1 and 5 years in prison. See Penal Law Section 60.12, 2. The question remains whether a defendant may waive a Section 60.12 eligibility hearing as part of a plea agreement. Though Section 60.12's language does not expressly point in either direction, the statutory structure and the animating purpose of the DVSJA alternative sentencing framework establish that the legislature did not intend for waiver of such a hearing to be a permissible condition of a plea. Contrary to the dissent's view, dissenting up at 1314, 1516, our conclusion directly rests on our interpretation of the legislature's intent, gleaned from both the statutory textual requirements of Penal Law Section 60.11 and the DVSJA's legislative history, in accordance with governing principles of statutory construction. See Matter of Peyton, Matter of Orabach. In enacting the DVSJ's alternative, reduced sentencing framework, the legislature intended to address what it found was a systemic problem with existing sentences as applied to certain domestic violence survivors. See Section 1, Supra. The legislative history and statutory background reflect the legislature's recognition of the national epidemic of domestic violence and goal of ameliorating the failure of prior law to allow judges discretion to fully consider the impact of domestic violence in making sentencing determinations. See Brenda W., quoting Assemblymen at 6. The legislature reimagined the appropriate sentencing ranges, including alternative non-incarceratory sentences in certain cases for this particular subgroup of defendants who were themselves victims of domestic abuse. The DVSJ is thus corrective action on a large scale, meant not merely to address excessive sentences on an individual level, but to recalibrate the criminal legal system to account for the trauma experienced by a class of defendants which led to their chargeable actions. The legislature balanced the need to hold defendants accountable with the need to recognize and address a pervasive societal problem, and it determined that consideration of defendants' histories of domestic abuse and their potential for rehabilitation must factor into sentencing determinations. Accordingly, the legislature enacted the DVSJ to achieve that equilibrium by allowing a survivor to present testimony and documentation at an evidentiary hearing in support of an alternative reduced sentence. See Penal Law 60.12(1). Interpreting the DVSJ to permit waiver of a survivor's opportunity to make the case for an alternative sentence upsets this balance and undermines the legislature's intent to correct a structural flaw in the criminal law as applied to this class of survivor defendants. Rather than grapple with the DVSJ's statutory framework or its legislative history in any meaningful way, the dissent concludes that no law or public policy prohibits a defendant from waiving the opportunity to prove their DVSJ eligibility in exchange for what they determine is a more certain and favorable plea bargain. The dissent fails to recognize that the legislature made a public policy choice in enacting the DVSJ, that survivor defendants have an opportunity through a Section 60.12 hearing for sentencing judges, not prosecutors, to fully consider the survivor's history of domestic violence and its impact on their criminal behavior, and, in turn, whether they are eligible for and deserving of an alternative reduced DVSJ sentence. To allow waiver of Section 60.12 hearings as part of the plea bargaining process would flout the legislature's intent that a particular subgroup of criminal defendants, domestic violence survivors for whom such experiences of abuse were a significant contributing factor in their criminal conduct, be able to have a judge evaluate whether application of the standard sentencing scheme would be unduly harsh in their individual circumstances, and exercise their discretion to impose an alternative reduced sentence. See Penal Law Section 60.12(1). This statutory purpose of correcting a systemic defect in the treatment of domestic violence survivors by the criminal legal system is one which transcends the individual concerns of a particular defendant. See Muniz. Moreover, because our system is predominantly one of pleas rather than trials, allowing waiver of Section 60.12 hearings would eviscerate this alternative sentencing pathway for the vast majority of domestic violence survivor defendants who plead guilty rather than proceeding to a trial. See Lafler v. Cooper, 566 U.S. 156, 170, 2012. Reality is that criminal justice today is for the most part a system of pleas, not a system of trials. That would be inconsistent with the legislative history and an incongruous result given that the legislature intended to expand, not contract or eliminate remedial sentencing for survivors. As with certain other rights, a survivor's right to a Section 60.12 hearing is too valuable, both to the survivor defendant and to the community, to be sacrificed in plea bargaining. See Rudolph. Contrary to the dissent's view, our decision today does not undermine a survivor defendant's autonomy or agency in the plea process. That argument ignores reality. First, the dissent can point to no examples of stymied plea negotiations involving a non-waivable right, and it utterly fails to make any argument as to why prosecutors would treat survivors differently. Second, the dissent's framing of Section 60.12 hearings as a bargaining chip that survivor defendants can use to their advantage during plea negotiations elides the inherent power imbalance between criminal defendants and the prosecution in those negotiations. Many legal commentators have recognized, and indeed taken as a given, the coercion inherent in the plea system, as, once the state arrests a person and charges them with a crime, the state has power over them. See, e.g., American Bar Association, ABA, Criminal Justice Section, 2023 Plea Bargain Task Force Report. The legislature understood as much because it described survivor defendants as victims of abuse that were at times re-victimized by application of the standard sentencing scheme, Assembly Mem. at 7. Indeed, nothing in the text or history of the DVSJA suggests that the legislature envisioned prosecutors would make a plea offer conditioned on the defendant waiving a hearing that might establish their eligibility for a judicially imposed alternative, reduced sentence. This makes plain that precluding waiver of Section 60.12 hearings will not disadvantage survivor defendants in plea negotiations. Either a prosecutor is persuaded by the survivor's history and circumstances that they should be sentenced under the DVSJ framework or not. If it is the former, then the prosecutor may craft a plea offer that takes their history of domestic violence into consideration, or choose not to oppose the defendant's request for a DVSJ sentence. We note that in line with the legislature's carefully crafted framework and its recognition of the trauma of domestic violence, it remains a defendant's choice whether to request a Section 60.12 hearing. As explained by counsel and Amici Survivors Justice Project and Sanctuary for Families, domestic violence survivors struggle with the effects of abusive relationships. A survivor may not be ready or willing to discuss their experiences in court. Therapy, family support, and counsel's legal assistance may all be part of the healing process, which takes time. We further note that while a defendant may request a DVSJ hearing, alternative sentencing is left to the discretion of the trial judge under Penal Law Section 60.12 and the Appellate Division in the exercise of its interest of justice power. See Brenda W.W. In sum, in enacting the DVSJ, the legislature determined that survivors are best positioned to know whether to seek relief, and judges are best suited, upon full consideration of a survivor's history, to determine the appropriate sentence that balances accountability and compassion. The appellate division order should be reversed and the case remitted to Supreme Court for further proceedings in accordance with this opinion. Order reversed and case remitted to Supreme Court, Kings County, for further proceedings in accordance with the opinion herein. Opinion by Judge Rivera. Chief Judge Wilson and Judge Troutman concur. Judge Holligan concurs in result in an opinion. Judge Canataro dissents and votes to affirm in an opinion in which Judges Garcia and Singas concur. Decided April 23, 2026.
Welcome to NYPTI's Decisions on the Go, using AI for over a decade to help you listen to New York State Court of Appeals decisions on the go. After the podcast, visit www.nypti.com/law to read the full decision.